The judiciary is investigating the motive of a man who set himself on fire outside the Supreme Court in Nairobi, reportedly over delayed justice. The man was carrying documents, a bottle of liquid believed to be petrol, and he stopped on City Hall Way, set himself ablaze, and was rescued by security officers. He sustained severe burns and was taken to Kenyatta National Hospital, and police collected his documents and clothes for investigations. Of course, authorities are planning to question him once he recovers. We'll get into that with the Deputy Chief Registrar and the spokesperson for the Judiciary. But good morning, Kwanza. So we don't do a, let's find out.
Good morning. I'm very well, and it is a real pleasure to be here. Let me also congratulate you on this show. I think it's about a month now.
Yep.
Yeah. Great show to have, to see how we can fix the nation, one conversation at a time.
Yes.
Addressing different aspects. This is really what we need for the nation. Let people know what's happening, see what are the solutions that we have, build this. This is our nation. Let's work at building it. So congratulations.
Asante sana.
Thank you.
Yes.
So yesterday, from what happened yesterday and what Mariam has just reminded us of the news from yesterday, what's the latest?
Yeah, so first, a very unfortunate and a chilling incident. There was this gentleman that came and stopped outside the Supreme Court buildings and then set himself on fire. And our security people responded very quickly. Just came up with the fire extinguishers and put out the fire. And we worked also with the police who are close by from KICC. So we were able to get an ambulance from the Nairobi City County, and he was taken to hospital. So we of course wish him a speedy recovery. As you correctly pointed out, the authorities are waiting for him to recover so that there is more investigation carried out on what exactly triggered that particular incident. But we are not, laying back as the judiciary. He had some documents which were taken by the police. We are seeking to establish whether there is any linkage between that incident and any matter that may be in court. So that is a matter that we are currently looking into.
All right.
Yes.
Do you have any update on his status in terms of is he, conscious? Is he in treatment, in surgery, anything of that sort?
He's in treatment, but I cannot talk about the latest position this morning.
Okay.
Yes.
That's all right.
We'll wait for any updates from you.
Yes.
And of course,
certainly.
It will be interesting to follow up on this and see what would lead somebody to do this.
Yes.
There are very many things that we keep talking about. The state of our mental health as a people in this country, and the triggers that are there in everyday life. It could just be frustration over one thing or the other, and we cannot take something like this lightly.
We can't. And we are not as the judiciary. We are not. I mean, we don't even know what it is, but we don't want to take it lightly.
Yeah.
So that is why we are going out of our way to just find out, is there any connection, so that if it's anything related to a matter that is in court, then we can pursue that further. But it could be anything, as we are saying.
That's true.
A matter outside court.
True.
It could be anything.
Okay. One of the things that we'll be discussing today for the next 2 hours, and we'll allow people to call in and engage with you, is if there's somebody who has a frustration about a matter in court, you can ask the judiciary spokesperson how to handle it, where it goes from here. Of course, you'll give us the structures that are in place, but also you'll get the feedback whether those structures are working, whether they're not working, and let's ask, so how do we fix it? Before we do that, there's something that we usually do. We're always three. Janet.
Yes, it's Janet.
Our girl Janu is unwell, and so she's been away this week.
Okay.
Yeah, she's recovering. She's on the mend, and we hope that she recovers fully by next week. She'll be here. There's something that she always does, which is giving a quotable quote, looking at what people have said previously. Could be somebody who's been on the show. Like, in future we may quote what you've said today.
Okay.
But this one, these words were said by somebody. I'm going to give you the words, ask you who said it. If you require 1 or 2 hints, I'll give you the hints.
Okay.
The future depends on what we do in the present. The future depends on what we do in the present. Who said that?
Give me some hint.
Hint number 1. Where do you think chapati originated from?
India.
Okay. This person was born and given 3 names. Mohandas Karamchand. I'm not giving you the third one. He died in 1948 at the age of 78 after assassination. He was popularly known by other names like Bapu, which means father, or Rastrapita, father of the nation.
I think I need to eat more chapati.
Died in 1948. Was called father of the nation. Yeah. Very well renowned personality from India. Was very big in India at that time. Yeah. His name is Mohandas, but publicly he's known, that name Mohandas has been, coined into something else.
Yeah.
Starts still with an M, and the second name starts with a G.
Gandhi?
You got it.
All right.
It's Mahatma Gandhi.
Good.
Yeah, he said it. And it's what happens in the future. The future depends on what we do.
Depends on what we do
in the present.
In the present. Very
what
correct.
do those words say to you?
Very correct. Very correct. What you sow now, that's what you end up reaping. So if you invest correctly, whether it's in structures, whether it's in systems, that is what you get in the future. You get the product of what you invest now. And of course, the converse is also true. If you do not, put something in place, then expect to reap the result of that lack of what you have not done. So very, very poignant statement, I think, about even where we are at as a nation, for institutions, in our personal capacities in our lives, and just generally speaking in life. So very true statement.
Yeah. Yeah. Our good constitution establishes the judiciary.
Yes.
As an arm of government.
That's true.
That's equal to the other two, the legislature and the executive.
Yeah.
And we were saying this earlier with Mariam. The legislature is comprises of people who are elected by the people, and they go into the legislature.
Yes.
The executive is headed by people who go to the people. They are elected to head the executive. The judiciary is headed by people who have not come directly from the people, but it's an institution that then is created, and the people who serve there are placed in a high pedestal. In fact, globally, the judiciary is said you have such a high pedestal that you're supposed to have to be like
Caesar's wife.
Caesar's wife.
Yes, above reproach.
Above reproach. What does that mean?
Yeah. First, let me say that the mandate of the judiciary, you've talked about the executive, you've talked about the legislature, the mandate of the judiciary is also derived from the people. In fact, the Constitution says that that power, that judicial power, is exercised on behalf of the people by the judiciary. And that is why in some countries, you'd find when a matter is brought before the court, it's actually the people versus. So in Kenya, we don't say the people versus whoever has been accused, but that does not, remove that responsibility. The law is very clear that the power that is exercised by judges, by judicial officers, is derived from the people. And because we are in a position where we act as an umpire, and that's a very important point. I'm sure it will come up again in this conversation. The judiciary is a referee. As a referee, you are expected to uphold very high standards. You are not, you don't act in a prejudicial manner towards one or the other. And so that is where the team has confidence, or the team ought to have confidence that the referee is going to be fair. The referee is going to hear my side, is going to hear this other side, and they'll have a just outcome. So when you talk about having reproach beyond Caesar's, being like Caesar's wife, who is above reproach, then that is the understanding that the judiciary comes in with clean hands, is going to be fair, is going to be an umpire that is going to justly, adjudicate over whatever is placed before it. Yes.
So that's what the Constitution then says, that judicial authority is derived from the people, like you've said.
That's true.
And this is Article 159. It vests in and shall be exercised by the courts and tribunals established by or under this constitution.
Yes.
In exercising judicial authority, the courts and tribunals shall be guided by the following principles. One, justice shall be done to all,
Yes.
irrespective of status.
That's true.
Justice shall not be delayed. Alternative forms of dispute resolution, including reconciliation, mediation, arbitration, traditional dispute resolution mechanisms, shall be promoted. Justice shall be administered without undue regard to procedural technicalities.
Yes.
The purpose and principles of the Constitution shall be protected and promoted.
Yeah.
The first two, justice shall be done to all, irrespective of status.
Right.
Justice shall not be delayed. Mariam, what do the people say?
Justice shall be done to all.
All, irrespective of status.
Right. Justice shall not be delayed. Let me start with justice shall be done to all. The feeling, not the feeling actually, in general, justice is done to some. And usually the some in this case is whoever is the poorer of the two. Whether it's in a civil case, a criminal case, whether it's in something that's of national importance, or it's me versus Eric Latif, right? A lot of the times, whether it's from a simple angle of being able to afford representation, and therefore you have a better chance of getting out of the justice system unscathed, or allegations of bribery, etc., or people swaying the judicial system. Justice shall be done to all. Justice shall not be delayed. Our court system is notoriously slow. I think, and you know this is not news to you, of course. You could be in court for 5 years, 6 years, 7 years over the same matter. When it's criminal cases, it's even worse because then people are forced to relive whatever it was that happened to them, be it violent attacks, be it gender-based violence, sexual assault, every time you go to court. And I know the SGBV courts are trying to deal with that.
Yes.
But those two, things are just very, very hard to see in the judiciary right now. Shall be done to all, shall not be delayed. Speak to that. And I want to start from the 2010 Constitution. What shifted in the judiciary from a legal perspective and from a public confidence perspective? And then have we gone back? Have we made a few steps back? Nazwa nimekuuliza maswali mingi. But start by addressing justice shall be done to all.
To all.
And
Yes.
justice shall not be delayed.
Yes.
Yeah.
Thank you, Mariam, for that question. So, I started by saying we are an umpire. The judiciary is a referee. So the judiciary deals with matters that have been brought before it. So we have agencies that bring matters before the court. We have got individuals that come to court to deal with matters between themselves in what we may call civil matters, matters between two civilians. So when these matters are brought before the court then sits and determines those particular matters. The judiciary is very keen to give justice to everybody. We don't discriminate and say that this matter, belongs to this type of person or whatever. It does not do that. But there are certain instances where, because of public interest, you might say, there are some matters where the law itself has said that this matter needs to be concluded within a particular period. So you find, I'm combining that with the second question. So you find, for example, like election petitions.
Right.
Because of the public interest, because of the anxiety that would be caused if these matters went, for long.
True.
And again, if you follow from the 2010 Constitution, there were cases that were notorious. You'd find a case has started from one election cycle to the next and is not yet concluded. So what justice is being done there? Right. So there are certain matters like elections that have to be concluded within a particular time. So if one looks at those types of matters, for instance, it might feel like this one is favoring the haves, because anyone going into elections generally is considered as being above, average. And so their matter seems to move a little faster. The other thing you'd find is that somebody might, if you have representation, everybody has a right
to
representation. But not everybody
can afford
representation. So that may have some bit of bearing. But that said, the judiciary has worked very hard to try to bridge that gap. So for instance, there are matters where representation is granted for very serious offenses, like murder, robbery with the violence, and others where you have vulnerable members in the society, like children, so that you have lawyers who are then able to follow up on the matter, represent this person, ensure that they are ready for trial. Because the delay is not always a factor that is a court connected matter. It could be that the person is not ready to proceed. And therefore, when that delay occurs, it really cannot be attributed to the judiciary. So we are very keen to ensure that justice is given to all. And what the judiciary has also done is to open up other avenues so that we minimize on the technicalities that Eric talked about in Article 159. So we have other alternatives, and we have pushed very, very hard on this. So for example, we have something we call the court-annexed mediation. The court-annexed mediation is where a matter comes before the court, and the court then appoints mediators and asks the person who has come to court to submit themselves to these mediators. The mediators then listen to the matter and they agree. If there is agreement, the matter is considered resolved. If there is no agreement, the matter then comes back to court to be able to. So that addresses the issue of delay, because we have a lot of cases that are in the system. Last year alone, there were over 500,000 cases filed. So against the number of judges we are talking about and judicial officers, we have 207 judges as we speak. We have 600 magistrates and cadis. So if you look at that versus the number of cases that have been filed, I mean, you are talking about quite a heavy workload. So it is our determination as the judiciary to reduce. And the Chief Justice has been very vocal about talking to the judges and judicial officers to push and work to reduce the backlog from those that are over 3 years to bring them all under 3 years. That's a very good target, but still in terms of the sense of speed, people still feel 3 years is a long time. But considering the sorts of resources that are available, that is a very, very tall order. And we are here to also just give that as a, this is the reality on the ground.
The other reality.
We want to do this better, but then we have to work with the numbers that we are talking about here.
The other reality, Honorable Ndemo, we are going into a break. You'll respond to this after this.
Yes.
Is as the judiciary, as the 600 magistrates and the 207 judges are working to clear the backlog and to address any new cases that are being filed, the justice system is such that, especially in criminal cases, you are going to be given bail or bond.
Yes.
If you can afford it, you gain your freedom as your case progresses.
That's true.
If you can't afford it,
you stay in.
Then we give you what we call state-sponsored accommodation.
Yes.
Now, there are very many people who are under this state-sponsored accommodation on account of them not being able to afford the bail and bond that's been imposed on them.
That's true.
When they continue serving 1 year, 2 year, when you hear 3 year pending cases, there's a possibility that we are talking about hundreds of people who have been incarcerated for 3 years, just waiting for their case to be heard.
Yes.
That is injustice. Whichever way you slice it, it's injustice. Let's address that after this break. It's 27 minutes to 8. Our guest this morning is the Deputy Chief Registrar of the Judiciary and Judiciary Spokesperson, the Honorable Paul Ndemo. We are asking ourselves, just like you've seen in that stub, is it justice for us or just us? Back shortly. So the Honorable Paul Ndemo, the Judiciary spokesperson as our guest. And before we went to the break, I was telling you, so when you talk about pending cases, like you said, 500,000 plus 500,000 cases filed last year alone.
Yeah.
And then they come and meet the cases that had been filed in 2023, 22, 21, and the previous years. How many cases are now before the judiciary in total?
So currently we have approximately 630,000 cases that are pending before the courts.
Where?
So
do you know how many are in the magistrate level?
So that would be approximately about 500, maybe 550,000 thereabout.
Wow.
Yeah, because the magistracy accounts for over 90% of the cases. Yeah.
So even just looking at the state of the judiciary and the administration of justice report for last year, 635,262 cases before the courts. Yeah. These are very many cases.
Many cases.
Being handled, if you say 90% of them are in the magistracy, there are 600 magistrates.
Yeah.
Now, that's very many cases for magistrate.
Quick math. Yeah, it's 1,000, over 1,000 cases. Actually, 10,000.
It is very high. The average.
Wait. It is, yeah.
The average is actually 1,600 cases
per
magistrate per year.
Per year.
Yeah.
1,000 cases
exactly
per magistrate
per year. So
how many working days do we have?
So you calculate that. You have 5 working days. You have to listen to those cases. You have then to retire to your chambers and write rulings and judgments over those particular matters.
Hold on, I'm doing the math in my head.
Okay.
We 5 working days a week
times
by 54 weeks, but we have public holidays.
Exactly.
5 times 54. It equals 270.
I taught 20 for public holidays to Bakina.
250.
Okay, we don't have 20 public holidays. I'm being dramatic.
Okay, let's just even say that we had
250. So let's work 250 working days to clear 1,600 cases.
1,600 cases. Divide by how many?
250.
250. 6.4 cases.
A day.
Yeah.
Per magistrate.
Yeah.
6 cases a day. And this is average. This is saying you deliver decisions on. You should be delivering 6 decisions per day.
6 decisions a day.
If you calculate it that way, it means I listen to 6 cases today and I deliver judgment on rulings 6 a day. So and I can tell you that if you look at what happened last year, we were able to clear 99%. The judges and magistrates were able to clear 99% of the cases. That is why that figure of 600,000, as high as it looks, could have been higher, because we had 500,000 cases that came in, about 519,000 actually, more specifically, that came in, but the judges and magistrates were able to conclude about 500,000 cases, which is about 99%.
That's
so that it's almost like a 1-to-1.
1-to-1.
So what then now was the over and above is what now went to add to become this over 600,000 that is pending, because part of this is backlog from the past that is coming. So for us to be able to effectively hit this backlog and eat into it and get down, you need some more numbers. But apart from the numbers, we are working, as I told you, on alternatives. We are looking at alternative justice systems like the court annexed mediation. We have 94 of our court stations across the country that are now applying this court annexed mediation. We've also done automation. Automation has been a big game changer, and you asked about it, Mariam, about post-2010 constitution. One of the heavy investments that we have made is really in technology. We have got electronic filing now for all our court stations across the country. In fact, yesterday was our first anniversary, having done this
across the country.
Okay. So you can file your cases from wherever you are.
Nastasikia file imepotea.
Utasikia file imepotea. Because you're filing your matter. So this what we are doing to also just ensure there's efficiency and also minimize on incidents like those ones of this file has gotten lost, this and this is happening. So those are the things that we are doing to try to bridge the gap.
Right.
So with this increased efficiency, and of course, we are very hopeful that we can get increased resources to have more personnel, then we can start to see gradually a reduction in this backlog. And we can, I can come here next year and say we are now at, the matters outstanding are maybe 400,000. 600,000 were filed. We were able to deal with most of them. What is left is 400,000. And gradually, we should be able to get to a place where we are, like a number of jurisdictions, other countries, where we are dealing with maybe 1 year, 2 years
at
max. You are able to start a case and finish that case.
I want to go back and look at the areas where, the citizens would feel the pain of the judiciary. Wangeshi Jack, so let's bring back the graphics again and look at just the distribution of the number of cases that we have versus the courts or the tribunals that they're in. You can see case backlog in the Supreme Court 7, but if you just look at where the most of them are in the magistrates courts, the Environment and Land Court 6,000, Employment and Labor Relations Court 4,000, you have the tribunals, the Small Claims Court, and then some also in the Court of Appeal and in the CAFI courts. Now, I can see that the tribunals that are just, also because tribunals, you have to clear the case within 6 months, right? And the Environment and Land Court has very many cases. Just looking at this distribution, I see the pain where the magistrate courts have such a huge burden. Now, the normal journey through the court system of an ordinary citizen is you are suspected to have committed a crime.
Yes.
You are arrested by police.
Yes.
They hold you for, within 24 hours, they must present you in court. Issue number 1, they take you to court and they tell the judicial officer, the magistrate, we are suspecting Eric, we'd like to continue holding Eric as we conduct our investigations. The magistrate says, Sawa, you can hold Eric for 21 days. Okay?
Yes.
So Eric anaenda ndani for 21 days as he is being investigated.
Yeah.
We raised that issue here a number of times, right? I don't know whether I should raise all of them or we go step by step, like address this one. I mean, why would a magistrate allow the police to continue holding me if they have nothing to bring me to court for? Why are you allowing them to hold me for 21 days?
Right. Do the investigations precede the arrest and the charge? Or do you arrest and charge and then investigate?
Yeah, that's a very good question for the DPP. However,
but we're talking about the magistrate who says Kandani.
However, I'm a former prosecutor, so I can answer that question. But I also bring the angle of the court. So what happens is when a crime is suspected to have been committed, sometimes before the formal proper charges have been laid out, there's what you may consider, there are standards that the prosecution has, and the prosecution will look at is there evidence on this? There's what they call the evidentiary test. Do we have enough evidence? Then number 2, there's something called the public interest test. Sometimes you'll find that what the prosecution has is what you might call just some basic evidence. There's some other information that is required, but there is enough material to show that this person is a suspect. So what will happen, this person is arrested, they are presented before the court, and the court then, using its discretion, will say, fine, if you're saying you need more time to firm up these areas, this investigation. For example, we found this person, we found this person in the house holding a knife that had blood on it, and the person who was dead someone who was dead was found in the next room. There was no one else in this place. Now, if this person is not arrested immediately, there may be a flight risk. by the time you try to get this
or
person,
a danger to others.
Or a danger to others.
Okay.
So this person will be arrested. That basic information is presented, and the court says, fine, you're saying you need to establish who lives on that building, whether this person says that they were not at the scene, for example, because they have a right to say whatever and say, I was not here, that was a look-alike or whatever. So the person is given, the police are then given time to just establish those facts.
And it's a matter of,
so
like
it is
said,
the court.
It's a matter of public safety. It's a matter of course, the person could be a flight risk, and I get that.
Yeah.
You're found, knife, someone dead,
Yeah.
such a precarious position, right? Then there's also the case of I stole Eric's chicken, and now I'm in court.
And we're investigating.
And we're investigating.
And
And now I have
police
to be
watching
inside for 21 days as investigations go on.
Yeah,
Am I a flight risk?
You didn't even steal.
Chicken
You're arrested
matters.
on suspicion.
On suspicion of stealing.
No, chicken matters. And that is where now, this is where the court comes in. The court will listen to what the prosecutor has to say and will say, no. On this matter, you don't need 21 days. Can you make sure that you have this case ready tomorrow? This other one, this is a complex case. It looks like there are things that need to be followed up. Maybe it is a terrorism-related case, or it is it's a bit more complicated. So this one, so the prosecutor might ask for 40 days. The court will say, no, we are giving you 21 days. So the court does not have to agree with what the prosecutor is asking.
Yeah.
But the court will listen, then make an independent judgment. Does it make sense that this particular case requires more time or not?
Paul,
Yes.
the complaint from the public is that more often than not, police officers will arrest you. Then you will be taken to court in the morning. In fact, you've been arrested, and then a prosecutor is just given a file. We have this person, and then we have to present them before court the following morning. And the immediate application is that we are investigating and we want to continue holding this person. And many times, a magistrate will say yes. Whether it's 7 days or 14 days or 21 days, a magistrate will say yes. Those 7 days, a police officer or prosecutor then comes back to court and says, oh, by the way, you arrested these 4 people you allowed us to hold. We have nothing against Paul or Eric or Chawaende. There's injustice suffered by me for 7 days, and that's an issue. Let me move to a second scenario. And the second scenario here is where, yes, we are ready. We'd like to proceed with the case. And with whatever, mention, blah, 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 before then you take a plea, bail.
Yes.
Many times, the complaints would be that if you went to remand prisons, you will find people who are there on petty offenses, and they are in remand because they have not been able to afford the bail imposed on them by the courts. Courts are aware of the congestion in the remands.
Yes.
The courts are aware,
Yes.
because NCAJ comprises prisons department.
That's true.
Which reports how many people they're holding in remand. So why does the judiciary continue doing this, imposing hefty bail terms for petty offenses? And we say this because we juxtapose it with somebody who has been arrested on suspicion of corruption, and the corruption case is about 100 million shillings, and then they're told to pay 5 million shillings bail. They'll afford 5 million shillings, and they'll go home. This person who's been told 5,000 shillings will not afford it at Alala Industry Area. Why?
So what we have done about this, because it's true that we have quite a bit of congestion. That's a fact. So what we have done under the auspices of the National Council on the Administration of Justice is to periodically have what we call a rapid response initiative, where we have the key players. So we have the DPP, we have the prisons, we have the judiciary, and we also have the probation officers come in so that we can determine which of these cases can we allow these people to go out. Because in as much as we are saying there's congestion, there are certain types of offenses where the court would be, your hands are sort of bound, because this is not this is not any other offense that has been that you've been charged with. You can't say because the prisons are congested, you've been charged with grievous harm. You've harmed somebody, you've maybe hit somebody, and you fractured them. You say no, because these are congested, so we are going to let you out.
No.
You cannot do that. So it is a systemic issue that must be addressed from a broad point. But in the meantime, what we are doing is we have, so if you start first from the place of, because we have those in remand. Remand is one. Those whose cases have not yet been concluded, cases are going on. Then you have those that are in prison.
Yeah.
So those that are in remand, we've had initiatives where those matters are brought back before the courts so that those bail terms are reviewed. That we have done a couple of times. Now, then you have those that are in prison. The ones that are serving jail terms, those ones we then now have this collective initiative to say this one was even sentenced to 3 years, but you know, they have 6 months left. They are well behaved. They can, you know, there's a good report. The probation officer says yes. The community where they came from is ready to receive them. Based on that, we then now have these people released so that we can decongest the system. Right. So that is what we've been doing to try to manage that. But as I say, this is a systemic thing. The prisons, and maybe you'd have them here one day, the prisons that were built those many years ago, they've not been quite expanded over the years. And so we are talking about the same capacity for a very, very, very long time.
But I think the issue here, and that is an issue we definitely need to address as well, because prisoners do deserve dignity.
Yes.
But the bigger issue at play is, why are these many people in remand or in jail for offenses that don't necessarily, you know, seem to fit the bill, or for petty offenses, right? Because even if we create bigger prisons, then it's just more space to have more petty offenders in prisons, right? I'm not saying we don't need prison reform, that's a whole different conversation. But for example, we have cases of someone sentenced to 2 years in jail for shoplifting lotion worth 780 shillings to please his bride.
Lotion worth 780 shillings.
Right.
Sentenced for 2 years.
Yeah. Another one, imprisoned for 20 months for being drunk and disorderly. That's a petty offense. If I'm not a lawyer, but I do believe drunk and disorderly is a petty offense, right? Are those miscarriages of justice? They are. And of course, without the context of if they had other, you know, cases. I'm just saying, just
that's
knowing
important to know. Yes.
that, just that 20 months for drunk and disorderly, 2 years for stealing a lotion. Is that a miscarriage of justice?
So you're right. On the face of it, it looks excessive. But again, it's important to find out what is the context. What is the context? Because if this is a serial offender, for example, then that is different from a first-time offender. But that said, we have come up with what we call sentencing guidelines that help the judicial officers to look at a particular matter, and then, you know, it guides them. The way the court works is that a magistrate has got a magistrate, a judge, a qadi. They have got what we call decisional independence. So I cannot call them. A judge cannot call them. The Chief Justice cannot call a magistrate and say, in this particular matter, this is how you must do it. So what we do is you provide guidelines, you provide, you know, you do capacity building so that we are able to understand and, you know, benefit the justice system. So when there is an issue that one is dissatisfied with, then there is the next level of relief that you can get. You then move to the next level of court and say, this was my case. I was charged with this particular offense, and I think the sentence was excessive. So there are very many cases where people appeal just on the sentence and say, no, I mean, I was charged with this, I was convicted, but I should not have gotten 2 years. And the High Court will say, fine, we agree with you, or we don't agree with you, serve your sentence and finish that. So there is a mechanism. Right. There's a mechanism for, you know, how to deal with any grievance.
How long have these sentencing guidelines been, you know, a thing?
Oh, they've been in place for some time, at least five plus years.
5+ years.
Yeah.
Okay, so then, yeah, we're still getting cases of people who feel that they were sentenced unfairly or excessively or punitively compared to the crime committed. So then, you know, are the sentencing guidelines being followed is the next question. Again, is that a miscarriage of justice?
So you see, these are guidelines to, as I said, one has...
You can't force.
You can't force them because one has discretion.
If someone is punitive.
One has discretion. Again, we've said there are circumstances that, could then determine why am I... Because it might be two people, same offense, whatever, but this one... this sentence, this particular sentence. So it is important to also look at what are the circumstances that one is looking at. But these guidelines for us are a general direction, like as you deal with this kind of matters, consider this, consider this, consider this. And if one is then aggrieved, there is a mechanism to, to take it up.
Some of these things affect people's, the things that we say, it leaves a bad taste in the mouth. Especially somebody like that who feels, look, yes, I committed the offense, but then the punishment is just too heavy. And then they watch the news and they see this other person has been found guilty of an offense, and this is the punishment that they're getting, that they're still walking scot-free. As they say, I'm appealing, I'm going to court, I'm doing this and the other. That person is free. I was sentenced to 2 years with a heavy fine as the alternative. So they knew that I could not afford the fine. So I am here for 2 years. And yet that guy is walking. What do you think? That it leaves a bad taste in the mouth, right? And that affects that person's perception of the judiciary and the justice system going forward forever. Let's discuss the overall picture of confidence in the judiciary and the issues that have been brought to the fore in terms of corruption in the judiciary and so on and so forth. In the next hour, we'll also open the phone lines. If you've got an issue that you'd like to raise with the judiciary spokesman, you'll call in and you'll be able to ask. This is Fixing the Nation, one conversation at a time at 8:01.
Your pen number.
Opportunity number, there you go. 0719 038 858. Right. So back to our conversation with the judiciary spokesperson. And we're saying you can call in, you can ask your questions, you can go onto YouTube and Facebook and Instagram and TikTok and X, and you can post the questions there. We'll ask them.
That's right. And we have a caller coming in from Migori who wants to ask Honorable Ndemo something. Good morning. Good morning, Sham.
Yes, good morning. Thank you for the opportunity. My question to the judiciary spokesman. I personally worked for the judiciary during the Judges and Magistrates Vetting Board hearings. And the key reason for dismissal of judges and magistrates was the issue of temperament and arrogance of judicial officers. At the same time, I can recall our Deputy Chief Justice, Nancy Baraza, former, losing her job for the infamous nose-pinching incident at the village market. Juxtapose this with the current scenario where Supreme Court judges refused to hear a senior counsel, thereby generally dismissing his constitutional rights and the rights of an accused person as enshrined in the Constitution. What has changed? Has the threshold reduced all of a sudden?
Thanks, Shem. That's a great question. Honorable Ndemo, has the threshold changed? Yeah. And maybe you can give context for our listeners and our viewers who may not be familiar with which senior counsel was, barred from being heard at the Supreme Court.
Thank you, Shem, for your question. This particular matter is actually in court right now, as we speak. So, from a legal point, we really are barred from discussing this matter. There's a legal rule that we call sub judice, and Shem, I'm sure if you work to the judiciary, you understand.
What is sub judice?
When a matter is pending before court, you cannot discuss that matter outside of court. Because it then has a way that it starts to influence, it may influence what is going to happen in court, or start giving public, perception a particular way. So, because the matter is in court.
Let me remove matters as senior counsel.
Matter in court.
Let me remove that one.
Yes.
He talked about when he was at the judiciary, a big reason for the dismissal of judges was temperament and arrogance.
Yes.
Speak to that. Is that a problem within the judiciary?
So, the reasons that are provided in the Constitution for the removal of a judge is misconduct. So misconduct is one of them. So there's misconduct, of course, there's bankruptcy, there is, you may just want to retire.
Wait, bankruptcy as an individual?
Yes, as an individual.
Oh, you can't be a judge if you're bankrupt?
Even a public
you can't
officer.
serve a public office.
A public office, no, you cannot serve.
Learn something new every day, okay.
You cannot serve. You cannot serve. So it then would have to be determined whether some particular conduct falls under misconduct or what is it that constitutes misconduct, and that's a subject of interpretation.
Everything is open to interpretation. He's basically saying judges are arrogant. I think that's the takeaway. Even now, and the thing we cannot talk about, which is in court, is still alluding to the fact that there seems to be a certain level of arrogance in the judiciary.
I think what Shem is asking is a very specific question, to be fair. It's not about the whole judiciary. It's a very specific question.
It's beyond that. He's actually not, from what I understood from Shem, he's not wanting us to discuss the merits or demerits of this particular case. It is the perception that it creates. Going beyond this particular case, oftentimes we've seen when a matter is raised about a specific, an individual judge or a court, it's taken to the Judicial Service Commission, requiring the Judicial Service Commission to open an investigation.
Yes.
Then we see the said judicial officer going to court to block the investigation or any action. All right? So I know you're going to argue that this judicial officer has rights, but what does that do to the overall perception that if I raise issues against a judge, then the judge goes to court. Fellow judges stop the proceedings of this particular matter. I, as an individual who complained about a judge, then I'm left hanging. And if you just look at that, just juxtapose it, how many tribunals have been established since 2013? How many judges have left office via tribunals since 2013? Right? So matters of complaints raised, we remember, yes, the former DCJ, Nancy Baraza, Justice Chitembwe, Justice Mutava. There have been, such cases. Justice Martin Muya had been removed, but then went to the Supreme Court and was reinstated. Justice Lucy Waithaka was taken to the tribunal, but it was stopped by the Employment and Labor Relations Court. There was an issue, removal of Justice Farah Amin, but she opted to resign before this matter went to court. If you just look at the number of successful tribunals, how many? 3, 4? And one of them was in the case of Justice Murungi, and it was on account of illness. Complaints from the public that end up into the judicial system that actually show that action has been taken, in comparison, few.
I think let's address the issue, because if you look at the way the law was configured, the way the law was crafted, the Constitution, it's supposed to ensure that by the time a judge is being removed, then it is not an easy process. And it is for good reason. You remember the beginning we said, this is the judiciary, judicial officers, judges are umpires. And our system that we have adopted in Kenya is what we call an adversarial system. So it is you versus me. We don't sit down on the table and agree and say, fine, you did this, give, take. But we are trying to encourage that in other ways now, what I was calling the alternative justice systems. But typically, it is you versus me. So what tends to happen a lot of times is when a party loses a matter, those complaints find their way to the Judicial Service Commission. So the commission has to sit down and determine and say, is this matter based on, a real issue of misconduct, or is someone coming here because they are aggrieved by the decision? Both of us generally will not be happy if this matter is found in your favor, Mariam, and you know, as the other party, you will feel that. So where there is suspicion or whatever, you find someone saying, no, this person was compromised and all. And if those complaints are just allowed to come in without due process, I can assure you it will be very, very difficult for there to be justice done. Because anything that you do, you know, it is going to be, this thing is going to be questioned. But we are not saying, I am not saying that it then gives a license for you as a judge or a judicial officer to do whatever you do to misconduct yourself. The law does not allow that, and should you do that, then it will catch up with you. But you also have rights. You are also a human being. You are also a Kenyan. So I cannot be dragged in the name of I am a judge or I'm a judicial officer. You have no rights. If you feel I have been aggrieved, I have a right to approach a court. Let that court then determine whether I have a case or I don't have a case.
Honorable Ndemo, I feel as if the legal minds in the judiciary have found a loophole, like a backdoor, through our constitutional process. The drafters of our constitution said, if I have an issue against a judicial officer, there's a mechanism for me to report. The Judicial Service Commission. The Judicial Service Commission shall independently investigate the matter. And if they find that there are grounds then to investigate this further, recommend to the president to form a tribunal in the case of a judge. And then that tribunal independently shall listen to the complainant, shall listen to the judge in question, and form an opinion. And that opinion then shall be either this does not hold or this holds. Okay? The legal minds of the judiciary have now introduced, I can go to court to block the formation of a tribunal, which is what now creates a perception that because you have a way of going to your peers, you can then stop my process of complaining against you to your peers. Secondly, the composition of the Judicial Service Commission is majority judicial officers. Out of 11, how many come from the judiciary? 5. And then others are lawyers. Now, the public would feel that even if I go to the Judicial Service Commission, these guys will protect themselves, each other. This person can go to court, and the court will protect them, and so I have no way of raising the matter. Response before we take a caller. We have Francis in Eldoret. Francis, just stay on the line. Listen to this answer, and then you shall ask your question.
Yeah. First of all, this is really tricky because this matter is actually in court.
Which particular matter?
As we talk, the issue about a judge going to the court.
Yes.
So I can only speak in a very limited fashion without going into the merits or demerits. But let me say this, that the going to court is not to stop the tribunal. That is not the issue. That is not the issue that is in dispute. It's not about stopping the tribunal. There are other issues that are being canvassed. And I think it would be speculative for us to say that one is going to their peers to stop this. The process, ultimately, the court before which that matter has come, the court must ultimately determine the issues and say, okay, the issues that you have raised have got merit or they don't have merit. And if they have merit, then this is the way to go. If they don't have merit, then you know, the Judicial Service Commission is going to handle them in a particular way. So it does not remove the power of the Judicial Service Commission. I think it is the issues, particular issues that are being discussed, and it is not a backdoor way. I think that's all I can say for this. So that
you're discussing one issue. I am not discussing any present issue. I'm discussing all issues, from a previous DCJ to a judge of the Supreme Court, to judges of the High Court, to those ones that we have seen here. Judge went to court and the court stopped the matter from proceeding to a tribunal. It's how the system is structured,
It's
and whether
gaming
this
the system.
It's
That's
gaming the system. And what that does to any member of the public who then would have an issue to raise about the integrity of a judicial officer. Pause. Let's hear from Francis because he has a different question. Francis in Eldoret, good morning.
Good morning. I have some few questions to Judiciary.
Yeah.
My first question is this: there is this power of mercy. This power of mercy has been crippling since 2010 in Judiciary. I don't know when will it become effective to assist the people. Secondly, there is a power of there is this resentencing of sentences of prisoners who are serving life sentences. You find many applications pending in court, yet it is just a symbol. The proceedings are just there. It is just a matter of reviewing the sentence. You find even others that the complainants are dead, and there are no more complainants, but the person is still serving the sentence in prison. So that can be reviewed again. There is again this. Why is it that you cannot find any prisoner serving a sentence of corruption? In Kenya, you find that many cases of corruption are just in courts. There is no any evidence of convicting those people. The last question is this: there is a lot of delays in typing lower court record of proceedings for appeals in the High Court. So for that long, why is it that hakuna machine mzuri za kutype hizo proceedings ndio ifike kotini mapema? Hiyo ndio inafanya watu wanachelewesha mpaka haki inapotea again. That's all I wish to say for now.
Thank you, Francis. He'll respond to those shortly. We have Karanja as well on the line. Karanja in Kiambu, good morning. Have we lost him?
Do we still have Karanja? All
right. Karanja, good morning. Okay, just respond to those ones.
Thank you, Eric. I think before I answer this, let me respond to what you talked about, the court stopping. Even where the court has stopped a matter that has come before it, where, for example, a judge or a judicial officer has brought that matter to court, this is not permanently stopping. Maybe that is a perception that we need to confirm. We need to clarify here. It is not that this has been stopped, it will not happen. It is stopped for a time to allow the issues that have been brought there to be, to be ventilated before that court, so the court makes a decision. So after that, then the other processes can continue. So it is not permanently stopped. I think it is important to clarify, so it doesn't look like it comes here, we stop it, and there's nothing beyond that. Okay. Francis from Eldoret, if I got you correct, the issue of the power of mercy, this has actually been implemented. It is a multi-agency framework that works under the presidency. So this is actually working, and there are matters that are forwarded to prisons for people to be considered, people who are serving sentence, and people are released based on now reports gotten from the prison, from the probation office. So this is actually in operation. Probably it's a question of sensitization that has not happened.
I think you were saying it's taking very long for these applications to be heard when people ask for the commuting of these sentences. Is it commuting? Is that correct term? But yes.
Yeah.
So you're talking about the timelines.
Yeah. Okay. So that is a matter that is really outside of the judiciary. But the judiciary is one of the players. The prisons are the people that have got the big responsibility here. But we also have representation from the Office of the President under the power of mercy. There was the issue, I didn't get your second question clearly, maybe you'll repeat that, about sentencing. But the one on prisoners, where there are no people serving corruption, there are actually people serving corruption on corruption offenses, quite a few. I think the most recent, we had the former governor for Kiambu. He is actually in prison as we speak on corruption charges. We also have the former governor of Samburu. He is also serving a sentence from corruption. So there are a number of persons who are actually serving on these corruption cases.
It's a perception again.
Yeah.
Where you look at the percentage of cases that go through to conviction stage on corruption versus the overall malaise of corruption in the country, and you feel that people are walking scot-free. How do we address this? How do we fix this? Because, I mean, the ball is tossed between the DCI, the EACC, the ODPP, the judiciary. In the previous regime, it was always that the judiciary is a bottleneck in the fight against corruption. Then it has come into the ODPP is a bottleneck in the fight against corruption. Bottom line, from where we sit as the citizens, we hear corruption all the time.
Right.
We see services not being offered to the citizens, and we don't see people in jail. Enough people in jail.
Right. Just before you answer that, is it okay if we just take one more call, because I don't want the call to drop?
Okay.
Karanja is on the line with us, and then maybe you can answer the two questions together. Good morning, Karanja. What's your question for Honorable Ndemo?
Hi, good morning.
Morning.
Hello.
Morning. We can hear you.
Can you hear me?
Very
We can
well.
hear you, Karanja.
Yeah, mimi nataka niongea Kiswahili for the benefit ya wale watu ya rika yangu.
Aina shida.
Now, mimi ni contractor and I want to showcase kesi yangu moja Nyamira Court. Ndio tuweze kutembea pamoja kwa sababu hii kizungu mingi imetuchokesha. It's like we want to take the third option. It is this way. Nilipewa kazi na wa China hapo Nyamira. They terminated the contract. Nikaenda kwa magistrate court. Koti magistrate akawa transferred when the matter was part heard. Alafu yule magistrate alikuja, refused a retrial ndio tuanze evidence upya. Akaanza na defense witnesses wa China. Hiyo evidence ndio alirely on the ruling. Nothing in the ruling was quoted from the proceedings the claimant. In fact, the ruling looks like the submissions, the defense. Now we went to the appeal. Koti ya jaji mzima, hiyo koti, aliamua akipitia document mbili that were part of the proceedings, the lower court, that we are missing. Now see, those documents were not in our custody. They were supposed to come from the lower court to the high court. Anasema the two documents are missing, and so we were not responsible to have looked for the document. The same court, the same office. The matter was dismissed at the appeal level. Why don't you tell us to just move on to the next level? Kwa sababu hii nchi does not belong to the small people.
Thank you, Karanja. Honorable Ndemo will speak to that in just a moment. Last caller, actually one more. Andrew in Nairobi. Good morning. Good morning, Andrew.
Good morning, how are you?
Very well. What's your question for Honorable Ndemo?
I'm putting my question to Honorable Ndemo. He's talking about the dispute alternative process. And like on a succession matter, maybe there's one party that is willing to go for that alternative dispute resolution, and they have another party has got muscles. They just want to proceed the matter because they are advocates. So why can the court make it to be a special trial before the parties are heard in court? We say let's have a tribunal, let's have a report from the chief professor, then that the magistrate may use that come report the chief na wazee kutoka baraza kujua ukweli wa mambo kwa ground, so that the court can be guided by that wisdom. Other than leaving just to the parties.
That's a good question, Andrew. Asante
Very
sana.
good one.
You want to start with Karanjas?
All right. We hadn't finished. I think there was one from...
There was another one from Francis.
Yeah, about proceedings, typing matters in court that take long. So what we are now doing is to have we actually set up a transcription center to start to type, proceedings from the different courts so that we can speed up that processing, because before you type those proceedings, then you are not able to appeal to the next level. That's what he was talking about. So that is being addressed.
When will it be addressed?
It is being addressed already.
When will it be ready? When?
No, it's already in operation. It's actually based at Milimani. We set it up like about a year or so ago, and we are now taking in from the different courts, but we are building its capacity.
Okay.
Because as we speak now, we've only done about 30 from 30 different courts. So, and we have 140 courts across the country. So it's something that is building, and we are confident that as we build the capacity of the transcription center, this matter is going to be permanently resolved.
So
and secondly, we're also looking at the automation.
When shall we have it in all courts available across the country?
We are looking at probably with the resources available, maybe the next 2 years. But in addition to this, we are also doing, we have, our services are now, we are automating many of our services. So we are currently piloting with a number of judges and judicial officers to type their proceedings directly.
Right.
Because they type their proceedings directly as they are listening to the matter, and as they type their proceedings, these are being uploaded onto the system, so that then they'll just be checked for quality, not writing, which is what we've been doing and we are still doing for most of our courts.
Right. Yeah.
So you write, then it has to be typed.
Right.
And then, you know, the transcribing, that is what is taking long.
Have you considered artificial intelligence? I think it would make your work a lot more easier, cheaper.
We are working on that. We are working on that right now.
And stenographers, because you're telling a magistrate that you listen and you're typing. They've been handwriting, yes, but now it's still...
Eric,
how about stenographers?
We would be very happy if we could get stenographers. We are working with the resources that we have. Remember, just 2 weeks ago, we cancelled an advertisement for judges, 11 Court of Appeal judges, because we didn't have money.
Right.
We cancelled an advertisement for 100 magistrates because we didn't have money. So if we could get stenographers, we'd be talking about getting 800 stenographers for the court. That would be perfect, because then the court can just listen, the stenographer is typing, the judge or magistrate is just taking their own, you know, few notes and the matter just moves fast. But in the circumstances, because of the limited budget that we have to work within the resources we have. So we are working on the transcription center, and we are also just automating, doing piloting with the judges and the magistrate, so that we can then increase.
Listen to the millennials, they have a solution.
No, it's AI, quite simply. It will take down the notes for you, transcribe whatever has been said in court, as long as it's like, you know, properly audible. And then then the burden of your office now becomes just to counter check and make sure
the quality,
that
the quality checks.
Their quality checks,
And
as opposed to
over time.
Yeah, and it does.
Because it's continuously learning.
As opposed to stenographers and 800 individuals. Quite a number.
Yeah.
Just a suggestion.
Okay. Karanja's question.
Yeah, so this is a case. He's talking about the proceedings. Very unfortunate how that matter proceeded, but the remedy that is there, unfortunately, because this is a case that he says started from magistracy, went now to the High Court. The High Court made its decision based on what was available. So if, unfortunately, I mean, he is aggrieved, the recourse that is available is for him to go to the next level and say, this is what happened. We are not satisfied with this decision of the High Court, and would like you to consider 1, 2, 3, and that is to the Court of Appeal.
Is there another way? Is there another way, like an ombudsman, where Karanja can go and say, look, I am challenging not the decisions that are being made, but the journey towards that decision, because that's what the issue is raising. There's a judicial officer, there's a magistrate. Magistrate is transferred mid-course, and the new magistrate that comes in does not start afresh, but just continues and appears to have picked one side, and then the Court of Appeal only carries on with that. So there's injustice here, and what you're subjecting Karanja and anybody else like him is to further distress and further cost by telling him, go to the Court of Appeal. Is there another way in which this can be handled outside of the merits and demerits of a case, but on process?
So unless you have the parties sit together and try to resolve that, Eric, if you talk about outside the process, because even the magistrate taking over the matter and continuing is part of what the law allows. Because sometimes you find, and transfer is normal, because you cannot be in a particular station for eternity. For part of managing the work is people get transferred, judges get transferred. So the law does allow for a matter to continue from where it stopped, or they can start afresh. So the arguments will be made before the court and say, for us in this particular matter, we want to start afresh. Or we want the matter to continue. Then the court will determine. So that is a merit issue. It is not a process issue. It's not a process issue. It's not about that this was not failed. No. It is a matter that is actually in the law. But in the procedure.
Paul, you know what happens in such cases. In such cases, somebody starts to imagine that the other party has found their way to the judicial officer, into the system.
Yes.
Then this is where now the perception of corruption comes in.
Yes.
If you went and try and convince Karanja that there was no corruption in this particular case, it's a hard task.
Yeah.
He also mentioned that the rulings made by subsequent magistrates only relied on, what did he say, two documents that were submitted like beforehand, as opposed to a ruling that is based on all evidence, all testimony, everything done prior to. Even if we're not starting the case afresh, the information should all be up to date, no?
What he's alluding to here is, so they disregarded my side and they went with
so I think
the contractors.
In fairness, of course one is aggrieved, and I empathize with Karanja, but let's remember, this role of being a referee is not a very easy task, because if you a judge or a magistrate finds in your favor, if you see me driving my car out of the court station and my window is rolled down, and then someone says hi and I wave at that person, it happens to be the person who was in my court, that already is a perception created. So when we are looking at the matters here, and they're talking about they only relied on these documents and this document, that is a merit. It is a question of merit of the person. And that is why the way to deal with that grievance is for you to go up the court, the next level, and say, look, I came before this court, this is my grievance. I am appealing on this particular issue and on this issue. So I know the question of perception is a big deal. And that is why, well, there's still the next level of appeal.
He appealed
because
two documents were missing, the matter was dismissed.
I think the two documents he referred to was the High Court, not the first court was about the court did not start the matter afresh as he wanted. So the one of the documents I think was now the High Court. You see. So this is a matter that should he desire can go to the next level. So it is not. It is really not a process.
Time-taking.
It's really not a process. A process issue, and that's one of the reasons why we have really been advocating for these other alternative justice systems, because these alternative justice systems, what they help to do is to build a sense of cohesion. It is not adversarial. We sit and agree and say, I did work for you. You charged me 10 million. But I think you should have charged me, 6 million.
Right.
You argue back and say, okay, fine, we want this matter resolved. Okay, fine, we'll do 7 million and that's it.
Alternative dispute. Just hold your thought just there, because I know you want to go into the question on alternative dispute resolution as well. There's just one guy called Korir who's on the line. Don't want to lose him as well. Then Shikanisha. Sorry to interrupt your train of thought. Good morning, Korir.
Good morning, sir.
What question do you have for Honorable Ndemo?
Okay, I have a question. There is these cases of corruption in the counties.
Korir Zima TV inakuconfuse.
Hello?
Tuendelee, Korir.
Okay, I have a question.
Yep.
Regarding these cases of corruption in counties, which you hear only mentioned. A huge amount of money has been embezzled, and then it gets away. You don't hear anyone being taken to court or prosecuted, and a lot of money has been mentioned to be embezzled. Like, for example, I'm calling from Bomet, and I know that recently a guy was caught with 121 stamps manipulating tenders and payments to fake tenders which have not been, nothing has been done in the county. And then it was just mentioned and it died there. No one knows what happened. And so the avenues, the corridors of justice, you don't know what is going on behind.
All right. Thank you.
I was kindly asking, how will the common Mwananchi get to know what's happening with these cases which are being mentioned? They are huge. It touches projects which could have assisted the public, and whenever it is mentioned, there is a lot of anger in the common Mwananchi, and if it is served, common Mwananchi will actually be seen justice as being granted to them.
Asante, that's a good question and a good point to raise. So let's go into Andrew's ADR.
Thank you, Andrew, for your question.
This is Korir, but Andrew...
Yes, we'll address Korir's question. So on the alternative justice systems, what we actually seek to do in court in many matters is the court asks the parties, have you considered, having this matter resolved out of court? And the court then appoints what we call mediators. Family matters, it could be children, a variety of matters. Go and discuss and seek to resolve. If the parties then go out and resolve the matter, then they come back and say, we resolved the matter and we are fine. Good. And that is an ideal situation. It's a very good situation because the outcome is then good for everybody. We were able to sit down around a table, discuss, there was a give and there was a take. And that is a win-win. Because
it's not all cases.
It's not all cases.
Because cases of defilement...
Not criminal cases, yeah?
No. Defilement...
not criminal cases.
Defilement is out. Criminal, for most of them, no. But then there are some simple matters. We disagreed and we fought. Simple thing. There was what we call an AFRI. People were fighting. There was no serious injury. Can I ask, have you considered, reconciliation? So that those matters, we are then able to just solve and move on. But then where parties cannot agree, the court cannot force them and say, you must go and sit and agree. So where one party is willing to go and mediate, the other person is like, no, let's see you in court, then the court is left to deal with it. And he mentioned succession matters, which is a very important aspect. What we have found, because succession now relates to dealing with the estate of someone who has passed on, and most of our cases we find people had not done wills. So, and we've also established that actually in most succession cases, they are not contested. There's no dispute. So what we are actually undertaking now is to encourage people in these matters, come and let us just, finalize them, and you can go and divide the estate. So that what is left now is only where there are disputes, where we are not agreeing on who should get what and what. So we are actually currently having what we call an RRI, a Rapid Result Initiative, on succession matters at the family courts, so that we can decongest those ones. Because those ones really, this is family. Dad passed on or mom passed on, and we are left, the matter is in court, and it's not disputed. So we are trying to resolve that.
Andrew's complaint or point of pain is when one of the parties refuses to heed the court's, plea to seek alternative justice.
Yes.
And he says, can there be a way in which the court can compel both parties to first start there and say, in this particular matter that has been brought before me, I'm looking at the threshold and I see this, the first point should be AJS, and then come to me. Can we get into that system where...
So the court actually does that and say, can you go and...
And that's compelling.
Yes, go and seek to resolve this. But then if at that point the person says, no, I'm not interested, then the court cannot force.
Can we?
Because I'm also seeing a situation where the arbiter in this question, or the mediator, could be perceived to be, for example, not fair. So I wanted to go to court.
Yes,
because I think I stand a better chance of a fair
people have got different reasons why they do that. But in fact, in a very recent case, what a judge did is to tell the parties, you are not disputing 1, 2, 3, 4, 5. Are you disputing? No. Are you disputing? No. This one is fine. Okay. This one we are going to give. This one's divide, so that what you're coming to court to decide now is on this one issue. That is causing a problem. But the court cannot force you. The court cannot force. The court will encourage for you to have the mediation or the arbitration, but it will not force you. But it is a very good way of trying to resolve these matters, because it creates a sense of justice for everybody. Everybody feels that we have been served here, as opposed to the adversarial, where if you leave it to the court has never been to your village, doesn't know how the shamba is, how you related. So the court will just look at the facts before it, and make addition and say, fine, you take this part, you take this part, you take this part. Right. You've left it to the court. So then once the court decides, then you're bound by that decision.
Whew. Time is not on our side. I would love to know.
The last one on Korir.
Okay.
Yes.
Corruption.
Yeah.
Corruption is a huge conversation. This conversation needs to be held in the country. It cannot be, and it will not be fought by one institution, by one entity. There must be collective effort to see how do we deal with the issue of corruption, whether in the public institutions, in the private, in businesses. This is a conversation that pervades the entire society. When we talk about many of these cases that Korir is talking about, this is a matter that, for example, starts. People know there's corruption here, but there's a whole process. There has to be an investigation that is carried out by their agencies like EACC that do that, or the DCI. They will do that. Once they conduct that investigation, then it goes to the DPP. The DPP will then make a determination whether or not that case meets the threshold. After the DPP determines that the case meets the threshold, it will then come to court. Once it comes to court, then there is another whole process where the prosecution must produce all its evidence, bring all the witnesses, and based on what is presented, then the court will make a determination and say, fine, you have met the threshold. And remember, this is a criminal case. So the threshold is also very high for you to be able to meet, to get a conviction on this. It is a criminal case.
Paul.
It is not on a probability.
Korir's thrust of the question was information to the public.
Yes.
So the public, for example, in Bomet, is aware of this particular individual caught, implicated in corruption. And then the case goes into court, and the public does not get to hear anything else that's going on. Unless it has been taken up by NTV and brought into the news, then the people in Bomet, hawajui kesi ilienda wapi. They can just see the guy walking around. They don't know. How can the judiciary improve its communication and updating at local level? In this particular court of ours in Bomet, these are the cases that are there, and this is the progress of the cases. At national level, this is where people can actually get to know information. Kesi ya Mariam iliendaje, I can get information.
No, I hear that, but what I understood this question to be asking is something they had about corruption, not in court. Not in court.
Not in court.
He wasn't talking about court.
Yeah.
He was talking about there was corruption here.
And then
it went quiet. You see, as the court, we will not come to comment on, we hear there's something that has happened here. Then what we will comment on is the courts. Okay. And I hear what you're saying, that we need to, inform the public, and we are very open as the judiciary. Right now, we are open. We want to engage with the public. We had our Judiciary Dialogue Day at the end of January, and part of that is exactly for this reason, so that the public can get to understand what is our role as the judiciary. Are there some particular matters? So if Korir was in that, maybe in Bomet court, because we also had a day there, and ask a question like this, we would say, fine, that matter, it's good you're asking about corruption, it's an important thing, but we don't have any case right now on this. It is probably being investigated, so that we can also sensitize the public about what are the different roles of the different agencies. But as I said, this is such an important conversation. The nation needs to put its head around this matter so that it's dealt with, from the systemic problems to the ethical issues that we have, to the cultural orientations that we may have,
Right.
so that this matter is actually effectively dealt with.
Right.
Yeah.
We have to end the conversation soon, but I want to take one last call from Augustine in Nakuru. Good morning, Augustine.
Good morning to you, madam. How are you?
Very well, very well. What's your question for Honorable Ndemo?
Okay, niko nauliza nafurahia hiyo conversation yenu. Ni nzuri sana
Asante.
Shida yangu ilikuwa kubwa. Kesi yetu ilikuwa ni tulienda kotini Nakuru. Tulikuwa na kesi ya shamba ya Mwinde kwa kununua ploti ya hewa. Kesi ikaisha Oktoba last year. Sasa kwenda kwa ule lawyer akatuambia tuandike application ya 2000 ya search, alafu na 10,000 ya application ya kustaki ule Muhindi, ndio kwa sababu pesa iko kwa plaintiff. Mpaka saizi hatujui ndivyo na bichi ni wapi. Sasa niko naomba kama inawezekana mtusaidie. Mimi niko Nakuru.
Hii kesi ilienda kotini ama ni iko kwa lawyer?
Ilienda kotini kwanza 2015. Imeisha last year mwezi Oktoba. Title deed iko kotini. Mpaka sasa hajapata title deed.
Title deed mliweka kama nini? Kama bond?
Ilikuwa kama bond. Title deed ilikuwa kama ile safety, ilikuwa kwa safety kotini.
Okay.
Lakini kesi tulishinda Oktoba. Mpaka sasa hajapata title deed. Sasa ule lawyer tulienda kwa lawyer atuambia tutoe application ya kuwa astaki ule Muhindi kwa sababu plaintiff alipo pesa zake. Mpaka sasa hizi hatujapata hizo pesa. Ndio nauliza ni haki kweli kuanzia Oktoba mpaka sasa hizi title deed iko kotini na kesi ilisha Oktoba.
Sawa.
Umeelewa swali?
Augustine, sijaelewa swali lako vizuri. Vile nakusikia ni kwamba ulikuwa na kesi yako ilimalizika Oktoba.
Ilikuwa kesi ya mamangu mzazi.
Kwa hivyo shida yako ni kwamba title deed bado iko kotini ama ni swali lingine? Kwa maana hapo sijakuelewa vizuri.
Title deed iko kotini. Na hiyo title deed ule wakati tulikuwa court number 1 high court. Mama aliambiwa apeleke title deed akaika yeko kwa safety. Mpaka sasa hatujapata title deed. Kesi ilisha kuanzia mwezi wa 10. Plaintiff kasemekana alipo pesa zake, kesi ende kotini. Yule plaintiff ni Muhindi, ako Nairobi Westland huko. Mpaka sasa hatujapata hizo haki zetu.
Kwa hivyo wakili ameandikia koti kuuliza kwamba title deed yake itolewe. Kwa maana kama kesi imeisha, unapaswa kupata title deed yako. Wakili ameshaandikia koti ili aweze kupata title deed.
Alituambia tutoe kwanza 2,000 ya search. Alafu akatuambia tutoe 10,000 application ya ile plaintiff ya kustaki ule Muhindi alipe grama kwa plaintiff. Sasa mimi kwenda kule kwa wakili, ule karani akaniambia ati hiyo pesa ambayo itatoka kwa plaintiff ati ni ya wakili. Sasa mimi nashangaa. Mpaka sasa tujapata title deed. Hebu nipeni mwelekeo.
Ile nitakuuliza, nenda hapo kotini hapo Nakuru, uweze upatie case number yako na uweze kuambia kwamba kesi yako ilisha. Na watakupatia mwelekeo kutoka hapo. Uko na case number yako?
Niko na case.
Ni case gani?
Ni case ya iko ni LSC. Nadhani kuna hapa kwa nini labda naweza kupigia simu baadaye nikuelezee. Iko court number 1.
Sawa.
Kwa land.
Wewe nenda hapo mahakama ya Nakuru uweze kuelezea hiyo shida, watakupatia mwelekeo.
Sasa nashukuru ndugu yangu.
Asante sana Augustine.
In the event that akienda pale kotini Nakuru asipate usaidizi, what next can he do?
No, he should be able to get help, but that's what I wanted to get. If he had the case number, I would have followed it up here, but he should be able to get help. If it's a question of the title deed being returned, I mean the case ended in October, he should be able to get his security documents.
Can we share his number with you so I can also give the case number?
That's fine.
And you can help follow up?
That's fine.
Sawa.
That's fine.
Thank you, Gus. Now, let's talk about this, an issue that we discussed earlier, which was the things that you're saying here today, the number of court stations in the country, the number of judges and magistrates we have, the efficiency of the judiciary and all. It will be about funding. But before I get to funding, I've just remembered another question that had been sent to me earlier, which was on English being the language of use in courts, or whether Kiswahili is also an official language of use in courts. If I want to file a case in court, can I file in Kiswahili? Niandike Kiswahili, ni file kesi yangu mimi Kiswahili, ni wasilishe kesi kotini, nije kotini, nizungumze kwa Kiswahili.
Kwa sasa ni Kiingereza.
Kwa nini?
Tunaweka Kiingereza. But we have, you see, the pleadings and all are filed in English, but then there is assistance if one needs to be able to understand, to be told what the process is, to be told what the documents are. We have that interpretation that that is actually currently being done.
Bwana msemaji, sikiza, you have made things easier,
yes,
such that I as an individual can go online and file my case.
That's true.
Sasa mimi nataka kutumia Kiswahili kuwasilisha kesi yangu kotini. Naweza andika kwa Kiswahili. Mtume kesi yangu kwa Kiswahili. Mkiniita kotini nije nizungumze Kiswahili.
Ukitaka unaweza fanya hivyo, lakini ile ambayo tumefanya kwa sasa. Unajua kila kitu ni taratibu. Unaanza hapa kisha unapanda unaendelea. Na kwa hakika kuna mahakama ambayo imeweza hata kufanya uamuzi wake kwa Kiswahili. Tuko na mahakama imefanya hivyo pale Mombasa. Kwa hivyo inawezekana, lakini tunasema hii ni safari ambayo tumeanza na tunaenda polepole. Kwa sasa document zetu ziko kwa Kiingereza, zile zinakuwa files kwa Kiingereza. Kwa hivyo hatua baada nyingine tutafika mahali ambapo tutaweza kuweka hizo stakabadhi na mambo mengine katika Kiswahili. Lakini kwa sasa ni Kiingereza.
Tukizingatia kwa Wakenya wengi wanaongea Kiswahili, si Wakenya wote wanaongea Kizungu. Right? Inclusivity.
Yes.
Tunawacha watu, we are leaving people out of the justice system. When we lock them out by basis of language, there's so many things people could plead guilty to a criminal charge, not knowing. Not because they have not properly communicated that mimi na Kizungu, hatupatani. Then you're there in court accepting things. No, it's very, very true and very, very possible. So is it, access to justice?
I hear you, but there's interpretation that we offer. Even sign language, we offer that at the moment. We are building capacity to get to those different levels. So there's interpretation. A charge is read in English. You're asked, unaelewa Kiingereza? Ama uelewa? Sema haya, sielewi Kiingereza. Sawa. Basi umeshtakiwa na kosa hili na hili na hili. Unasemaje? Guilty, not guilty. Then you plead. So it is a process. We are heading there.
Masaa mawili yameisha.
Nashangaa.
Tumefika tamati.
Tamati. Mko mmeniuliza swali juu ya hela, pengine uko na hela ya kutupatia. Tunahitaji hela sana.
The Judiciary Fund, final, how much do you have right now in the Judiciary Fund? And is it a fund that is ring-fenced, or do you have to plead for the fund?
So the fund is, first is in the Constitution. By the way, it's the only fund in the Constitution that was given to a body. The other funds are like the consolidated fund for, operations broadly in government. Yeah. But in terms of an institution, it's only the judiciary. And that should be able to also show that the framers of the Constitution understood something, that this job of a referee will get you into trouble a lot of times.
It will.
So you need to. So it is not ring-fenced, but the understanding of the Constitution was that it's supposed to be funded so that there is that independence. You are able to operate that way. So it is not ring-fenced. Our current budget is 22 billion. What we had sought in this financial year was 44 billion. In the next financial year now, which is coming, we've been given 24 billion. So there's still quite a deficit, and there's a lot of things. I tell you, like I just mentioned about the Court of Appeal. Let me just give that example. The Court of Appeal has got 29 judges. These judges are churning out judgments about 70 to 100 every week. The backlog that is there will take several years for us to get to, being real time. But if we got the 11 judges whose advertisement we cancelled 2 weeks ago, within a period of less than 2 years, we can become real time.
Right.
We can actually become real time.
We have to end it there. I know the financial
So
constraints
magistrates
are
and
many.
all also, same thing, capacity.
Agreed.
Constructions, we would be able to offer better services, but we are trying with the limited resources, and we are committed as a judiciary to be sensitive and to offer what we can to the public.
All right. Thank you so much, Honorable Ndemo, for making it here this morning, of course, for answering our questions and those of fixers across the nation. It's fantastic that we're able to have people like you come and speak to people directly, give them a way forward. Hashtag remains Fixing the Nation NTV. In the next hour, we're Let's Be Forgetting with Eric.
Yep. And lest we forget, as we see an MOU that was signed by the president and I don't know whether people are calling him former opposition leader, Raila Odinga. And one of the things that they committed was to uphold the rule of law and justice for those that have suffered in post-election violence. We'll be joined by Frank Otieno, who was shot last year during demonstrations. He was admitted to hospital for 2 months and is among many who are seeking justice since then. There are many who suffered injury or death in 2013, in 2017, not even going into the 2008 post-election violence, which documented very many people. That's what we're asking ourselves. Lest we forget, there are people who are still seeking justice as we see handshakes.